Hello and welcome to Jury Research Academy's YouTube channel. In this video, we will be analyzing the third sample paper which CLAT has released. As you guys are aware, CLAT has already released two sample paper for you guys to attempt and to familiarize yourself कि कैसा syllabus है, कैसा pattern है, किस type के questions आप exam में expect कर सकते हैं. So in that line, they have also released the third sample paper. The first two sample papers were on criminal law. This one is on constitutional law. और ये काफ़ी important set of questions हैं जिसको आपको डिटेल में एनालाइज करके देखना चाहिए. हाउ टू स्ट्रीमलाइन योर प्रिपरेशन. बिफोर वी स्टार्ट, वी हैव लॉन्च्ड अ केस बुक एंड मॉक बुक एज पार्ट ऑफ द क्लैट पीजी प्रेप किट. इसमें आपको 2017 से 2023 के केसेस मिलेंगे और काफ़ी सारे मॉक टेस्ट मिलेंगे फुल लेंथ ऑन द रीसेंट पैटर्न ऑफ क्लैट. तो अगर आप इंटरेस्टेड हैं, यू कैन चेक आउट द डिटेल्स एंड बाय दिस बुक फ्रॉम द लिंक इन द डिस्क्रिप्शन. इसके अलावा अगर आपको ऑनलाइन टेस्ट सीरीज चाहिए है फॉर ALET PG और CLAT PG मॉक टेस्ट, देन यू कैन ऑल्सो चेक दोज आउट फ्रॉम द लिंक गिवन इन द डिस्क्रिप्शन, जिसमें दोनों में आपको 10 फुल लेंथ मॉक टेस्ट मिलेंगे ऑन द रीसेंट पैटर्न. अब आते हैं थर्ड सैम्पल पेपर पे. सो ऑन योर स्क्रीन्स यू कैन सी कि ये जो पैसेज है, दिस इज द पैसेज दैट दे आस्क्ड. अब ये थोड़ा लंबा पैसेज है, सो इट इज गिवन इन 2 screens. As you can see, this passage is taken from the judgment of Bijoy Emmanuel versus State of Kerala, which is a landmark judgment on constitutional law. तो इस पैसेज को जब आप पढ़ेंगे तो यू विल गेट टू सी दैट दे आर टॉकिंग अबाउट द इशू ऑफ नेशनल एंथम एंड हाउ सम स्टूडेंट्स हु वर बिलोंगिंग टू द जेहोवा फेथ दे रिफ्यूज टू सिंग द नेशनल एंथम. तो इस केस में कोर्ट ने आर्टिकल 19(1)(a) को साइट किया है, 19(2) को साइट किया है, एंड इट हैज़ ऑल्सो एनालाइज्ड ऑल ऑफ दिस in light of Article 25 of the Constitution. So once you read the passage, it becomes quite clear that the case is dealing with fundamental rights and also fundamental duties given under Article 51A of the Constitution. And now Bijoy Emmanuel is a very landmark case, which I'm sure all of you must be aware. Whenever you would have read Article 19 and Article 25, you would have read this judgment particularly. अब आते हैं questions की तरफ. तो सबसे पहला जो question था, that was with respect to Prevention of Insults to National Honor Act 1971. So they are asking कि section 3 of this law penalizes which of the following. Now it is understandable that you guys have not read this law, but अगर आप common sense भी apply करें and if you look at the facts of this case and even if you read the passage that is given to you, it becomes very clear that this law relates to not singing of national anthem, or it relates to basically symbols of national honor, and it relates to preventing insult to those symbols. तो अगर आप options देखेंगे तो all 3 options seem like they would have been covered under this law. तो पहला option, which is refusal to sing national anthem when legally required to do so, refusing to sing when part of a group engaged in such singing, and intentionally preventing the singing of national anthem, all of them are covered and penalized under section 3. So even though you haven't read this law, by applying common sense and your knowledge of this particular judgment, you could have answered this particular question. अब आते हैं सेकेंड क्वेश्चन पे. सेकेंड क्वेश्चन थोड़ा आपको ट्रिकी लग सकता है, बट अगेन अगर आपके कॉन्सेप्ट्स थोड़े से क्लियर हैं एंड इफ यू नो अबाउट दिस जजमेंट, यू कैन आंसर इट. सेकेंड क्वेश्चन में वो पूछ रहे हैं, इफ़ यू अप्लाई द सिचुएशन इन द एक्सर्प्ट. तो इस सिचुएशन के जो फैक्ट्स हैं, यानी कि बिजॉय मैनुअल के जो फैक्ट्स हैं, अगर आप इसको रोनाल्ड डॉर्किन के जो उनका वर्क था टेकिंग राइट सीरियसली, अगर आप इसके कॉन्टेक्स्ट में एनालाइज करते हैं एंड विद इन द फ्रेमवर्क ऑफ आर्टिकल्स 19 एंड 25, तो ये सिचुएशन इनमें से किस चीज़ को रिजेंबल करती है. ठीक है, अब हमें इसमें से सबसे क्लोजेस्ट ऑप्शन चूज करना है. फर्स्ट ऑप्शन इज राइट टू एंगेज इन ओनली कंसेंचुअल सिंगिंग ऑफ नेशनल एंथम. दिस इज नॉट ट्रू, बिकॉज इस केस में कोर्ट ने बोला था कि इट इज़ नॉट जस्ट अबाउट कंसेंचुअल सिंगिंग और नॉट सिंगिंग, इट इज़ अबाउट having your belief system under Article 25 while also respecting the national anthem. तो पहला ऑप्शन इनकरेक्ट है. दूसरा ऑप्शन है कि there is a legal right to not sing the national anthem. This is also not true. Third option is there is a strong right to decisional autonomy which should not be curtailed by law. नेक्स्ट ऑप्शन है a moral and ethical right which is over and above the constitution. तो फोर्थ ऑप्शन तो इनकरेक्ट है क्योंकि moral और ethical rights are not above the constitution. तो अगर हम एलिमिनेट करके देखें तो ऑप्शन सी turns out to be the right answer. As I said, this is a little tricky question because it requires you to apply your reasoning skills in light of your understanding of jurisprudence as well as constitution. Now coming to the third question. Third question is with respect to Article 19(1)(a). So they are asking that with your understanding of 19(1)(a), which of the following is true? So all the options are true because first option says कि right of freedom of speech and expression is only guaranteed to citizens, which is true because Article 19 only applies to citizens. Second is right to freedom of speech is narrower than right to expression, which is also true. Third is right to freedom of speech may be suspended during periods of emergency. This is also true. So all three options are true, hence the right answer is all of the above. Next question is with respect to the recent judgment in Aishad Shifa case, which was relating to the hijab ban. Now in this case, the two-judge bench of the Supreme Court was divided, and that is why a split verdict came, where one judge, which is Justice Hemant Gupta, he was in favor of the hijab ban, whereas the other judge, Justice Sudhanshu Dhulia, he was not in favor of the hijab ban. So now they are asking questions on that judgment. So they are asking ki in this case, while dealing with hijab ban, Justice Hemant Gupta said that the judgment in Bijoy Emanuel is not helpful in the Aishad Shifa case. For what reason? So the right answer to that is option A, because according to Justice Gupta, the government circular in Bijoy Emanuel applied to secular as well as religious schools, whereas the one in Aishad Shifa only applies to secular institutions. So that is why he said that Bijoy Emanuel is not applicable to the facts of the case of Aishad Shifa. Now coming to the next judgment, they have asked the same question but from the angle of how Justice Dhulia decided it. So now they're asking that the Justice Dhulia held that the case of Bijoy Emanuel was squarely covered the case of Aishad Shifa. What was his reasoning? So his reasoning was that the petitioners in both cases profess certain practices as part of their faith and as part of their religion and social practice. So if you would have read the summary of hijab ban, you would have come across the rulings of both the different judges and the reasoning that they have applied. So if you have read those cases, then you would have been able to answer these two questions. Coming to the next judgment, which is again on Aishad Shifa's case. So now they're asking that in the recent judgment of Aishad Shifa, dealing with hijab ban, Justice Dhulia held that argument of petitioners on essential religious practice was not needed. For what reason? So Justice Dhulia was of the opinion that a religious practice need not be proved essential in order to be protected under Article 25(1) of the Constitution, and that is why he said that there is no need to prove that hijab is indeed an essential religious practice of Muslims. Coming to the next case, the court is asking again question from the Bijoy Emanuel case. They are asking that in Bijoy Emanuel, which of the following rights were said to be violated? Now, even if you don't know the answer to this question, although if you know the facts, you would be aware that this was about violation of Article 19 and 25. But even if you don't know, the passage in itself does mention it. So if you would have read the passage carefully, you would have found the answer to this question in the passage itself. Coming to the eighth question was about one of the cases on right to religion under Article 25. So they were asking you the name of the judgment, which was relating to the Anand Marg sect. So this was an easy question because the answer to that was option B, which is Acharya Jagdishwar Anand versus Commissioner of Police. The next question is relating to Khadak Singh versus State of UP, which is a case on privacy. So in this case, the Supreme Court's constitutional bench held that department regulation or circulars which do not have a statutory basis, what would they be? So the right answer was that they would neither be law under Article 19(2) to 19(6), nor would they be procedure established by law under Article 21. Now it is understandable that you will not know the entirety of this case because this is a landmark case and generally we only read the summary of these cases. But such questions also have to be answered on the basis of common sense. So if you read the first two options, it becomes clear that both seem to be correct and therefore the answer will not be neither A or B. Okay, and since both appear to be correct, the only answer can be both A and B. So even with no knowledge about that case, you can still answer based on your basic understanding of the subject. Now coming to the last question was with respect to a recent case. Again, this was about having your basics clear even if you have not read the judgment, because the question was that in the recent judgment of Ravinder Kumar Dhariwal versus Union of India, Supreme Court held that the concept of reasonable accommodation is a part of what? Now generally the doctrine of reasonable accommodation is used in the disability rights jurisprudence. So whenever the court is talking about rights of persons with disabilities or any other minority community, they basically talk about the concept of reasonable accommodation, and this concept now has become part of Article 14 and even Article 21. So looking at that conceptual knowledge, the right answer was that this reasonable accommodation concept is part of right to equality and against discrimination. So that is why option A was correct, because all the other options are not making it a part of both right to equality and right against discrimination as well. So even though you might not have read this judgment, you can still answer it if you know what reasonable accommodation doctrine is. So this brings us to the end of our analysis of the sample paper, the third sample paper. If you have any questions or queries, you can leave them in the comment section. And if you like this video, please like and share and subscribe to our YouTube channel.